Good morning to everyone. Welcome to day 7 of our hearing, and welcome also to Ms. Olano. Before we start talking with you, I just briefly address the parties. Our secretary has circulated the time log yesterday and asked whether the parties have reached any agreement on the timing of the next 3 days. Claimant, do you have any comments on that?
Yes, good morning, members of the tribunal. The parties did discuss. So Friday is set aside for the closing. If you don't count in the closing time, then we have it in the next 3 days, which includes today, allocated a total of 18 hours and 47 minutes left for witnesses and experts. That's jointly. If we continued on the regular schedule, we would have 16 hours and 30 minutes. So we have a slight surplus. We would suggest jointly that, subject to the tribunal's availability, of course, that to make up some of the time, we would reduce the lunch breaks to 40 minutes on all 3 days, today, tomorrow, and on Thursday. That today and tomorrow we would sit, and again subject to the tribunal's availability, until 6 p.m. But I think it's the strong preference of both parties on Thursday to finish at 5:30, since we have some homework to do for the closings on the following day. That may not catch up all of the time, but hopefully a substantial amount of the time.
And does respondent agree with this proposal?
Yes, with the precision that I can't. There's no equivalent in English, so the Thursday 5:30 is a hard stop. That's from respondent's perspective. So everything else we are in accord.
Yeah, we are fully fine with this, so we can do it exactly as the parties have proposed. Our question would be whether you would like to start in addition in the morning earlier at 9, or no?
Not from respondent's perspective.
Okay, understood. So then we will proceed like the parties have proposed, and we will from now on reduce our lunch break to 40 minutes. And we'll end the hearing day today and tomorrow at 6 and sharp at 5:30 on Thursday. This is understood, and then we can turn to you. Welcome, Ms. Olano. This is a tribunal. In this case, I'm here with my co-arbitrators, Professor Tawil and Dr. Kremades. My name is Inka Hanefeld. I'm the presiding arbitrator in this case. You should have in front of you a declaration under Article 35 of the arbitration rules. Would you please be so kind to read out this declaration?
Sí, cómo no. Buenos días.
Yes, certainly. Good morning. I solemnly declare, upon my honor and conscience, that I shall speak the truth, the whole truth, and nothing but the truth.
Let's turn to your 2 witness statements. It's Exhibit RWS 5 and RWS 12. Do you have the witness statements in front of you?
Así es. Sí.
That is correct.
Can you confirm that these are your witness statements and that they correspond to your recollection, or is there anything that you wish to amend or correct?
No, they're fine. I confirm.
Then we turn to respondent for questions.
Thank you. Good morning, Ms. Olano. Your witness statements, are they based on your personal knowledge and experience?
Sí.
Yes, that is correct.
Please describe your educational background.
I am attorney specializing in administration and tax technique. I graduated in 1995 at the Pontificia University of Peru.
What is your current position?
Actualmente soy presidenta de
I currently preside the tax court.
Position.
Starting on November 14th, 2006.
What are the responsibilities of the president of the tax tribunal?
Well, I have various responsibilities. On the one hand, I plan budgets, operational plans. I represent the tax tribunal. I preside the chamber, sitting and bank, and I also oversee management plans, operational plans. I also verify issues that have to do with staff and vocales. I also need to create the specialized chambers and appoint the presidents. I supervise and coordinate the technical and administrative task of the tax tribunal.
The tax tribunal have law clerks, in Spanish, asesores, assigned to them. What is the role of a law clerk?
Sí,
Yes, the specialized chambers have law clerks. A law clerk is support staff that helps vocales in resolving file records. The person has to look into the arguments, the various positions, and also prepares a draft project together with the presiding vocal ponente, that is the one that has the file record assigned.
What is a substitute law clerk, or in Spanish, an asesor suplente?
bueno, en términos
Formally, there is no substitute law clerk, but what does it mean? It is a temporary law clerk that is assigned to a chamber or to a different area depending on the needs.
Do temporary asesores have the same functions as asesores?
cuando están en la sala,
Whenever they are in the chamber, they do have the same function. Whenever they are in the chamber that they work at.
And do law clerks decide cases?
no,
No, they don't. The law clerks are support staff. The law clerks do not make any decisions. They do not have any responsibility. The vocales are the ones that make a decision. First, the one that has the file assigned, the one that has to decide whether they are working along the same lines. This would be for the all the adjustments to be made. And finally, that is the party that will be supporting in the session with the other vocales, because at the end of the day, the party that has to decide are the three vocales, and this would be the case of the tax tribunal rapporteur or ponente.
Úrsula Villanueva.
Úrsula Villanueva
Ursula Villanueva was law clerk for the president's office, for the president, and also specialized law clerk. She was the chief of the technical office. She had several positions. She's currently a vocal. No, she was not. She was law clerk for the president.
Ms. Villanueva to act as temporary law clerk to Chamber 1.
Well, when she was assigned to Chamber 1, that was at the request of the presiding vocal that also had these files assigned to her, and this was the presiding vocal, and we were in a situation in which we had no clerks, and that's the reason why she requested the support.
On the basis of which of your responsibilities as president did you assign Ms. Villanueva as temporary law clerk?
Well, I have a very broad mandate under the regulations that establish that I need to supervise, coordinate administrative technical work, and that is translated as me having to manage resources whenever needed.
Claimant in this arbitration has submitted statements from a Mr. Estrada, a former law clerk in the tax tribunal. Have you read those statements?
Yes.
Claimant and Mr. Estrada have alleged that you interfered in the cases of Cerro Verde that were before the tax tribunal by assigning Ms. Villanueva, whom claimant alleges was your assistant, as temporary law clerk to Chamber 1 and directing her in the drafting of the resolution in the 2008 royalty case. What is your response to that allegation?
Bueno, que es totalmente falso.
Well, that it is completely false. As I explained before, if Ursula Villanueva was assigned to Chamber 1, it was at the request of the vocal in a context in which there were no law clerks, and I never interfered with the resolution of the dispute, and I never guided her to make one decision, for that resolution to be one way or the other, because it would be the vocal ponente, the one making a decision. The three vocales are the ones that make the decision at the specialized chamber level. I do not make a decision.
Mr. Estrada has also alleged that there was a legislative decree in 2012 that, if implemented, would have provided performance bonuses to vocales and the president of the tax tribunal, and that the prospect of bonuses motivated you to push vocales to resolve Cerro Verde's cases quickly and in Sunat's favor. What is your response to that allegation?
The same, but it is completely incorrect, at the very least. There was a legal provision that, as part of some strengthening standards for the tribunal, established a bonus for the vocales and also a bonus for the other practitioners within the tax court, but it was never implemented. But those bonuses have nothing to do with the assignment of the records of cases or the decision on those records or files. Within the tribunal, we follow goals and objectives, and based on that, we assign the case records, and we also resolve those case records. So one thing is not related to the other one.
Process by which vocales are confirmed or retained in their employment, which in Spanish is called ratificación. Please describe this process.
Sí.
Certainly, there is a confirmation process for the vocales that takes place every often, and that is regulated. There is a supreme decree that establishes the phases and also the characteristics of this process. This ratification process is in the hands of a specialized commission that is presided by a representative of the minister, and it is also integrated, or it's also composed of members of the civil society that are the deans of the oldest national private universities, and I am also part of that role. I am another member. The confirmation process has several phases. One of them is the assessment of the academic activity during that period. There is another phase that is the assessment. There is a psychological exam as well as an exam on the qualifications. There is also the assessment of the quality of the person that is in charge of an expert, legal secretaries that have nothing to do with the tribunal and that assess the resolutions. 3 are chosen by the tribunal and the other 3 are chosen randomly before a notary. So there is another phase that has to do with a management report that is my own responsibility under the regulations. This management report does have some objective portions. This is objective data. What do we measure? We measure the performance of the vocal given the average. Also, what the contribution is to reduce the number of case files that still have to be decided. What is the number of older case files that are decided given the average of the vocal? Also, how much do they participate in the analysis committees to take some of the topics to be considered by the tribunal sitting en banc? So this is, the report is a description of the results, and finally we say the vocal is above average, is at average, below average. And we also highlight or point out the areas that are where that person excels. And then that would be the management report, and finally there is an interview.
Next confirmation process.
Well, there is no specific date right now. We are currently having a competition. There was one in which the candidates did not pass the exam, so we have initiated another process. The ministerial resolution was just passed while we are here that has drafted the basic terms drafted by the Commission for that competition. That will take 4 or 5 months. Then the Commission will determine the ratification process and when it will take.
Me gustaría preguntarle quién.
I would like to ask you who appoints the president. Well, it is an appointment. It is appointed by supreme resolution, a supreme resolution by the president and also the Minister of Economy and Finance. Who may revoke the appointment? How? In principle, it was an appointment based on trust. That is, there could be, if there was no agreement, the position as president could come to an end, but then there is also a ratification process, but it hasn't taken place. Do you consider that yours is a political position, or are you part of the judiciary? No, this is not a political position, and I am not with the judiciary. I am a public servant. I have a career in the public sector. I worked before in the economy and finance ministry. I was part of the tax policy department that now is public revenue. And I started early in the Ministry of Finance. Thank you very much.
So please go ahead, Clement.
Good morning, Ms. Olana. It's a pleasure to see you again. I hope it's mutual. Let me ask you a few questions, and let's just start with a big picture question. The tax tribunal, would you agree, is the last administrative instance when it comes to tax and royalty matters? Is that right?
Yes, the tax tribunal is the last administrative instance, and under the code, if there is disagreement with the resolution issued, there could be an appeal to the judiciary.
Tribunal forms part of the Ministry of Economy and Finance, right?
Yes, it is part of the executive.
Of the Ministry of Economy and Finance, right?
Yes, but we do have functional independence. Administratively, we report back to the ministry, but we are independent, and that's the way it is established.
I just remember from seeing the building in San Isidro, which has written Ministry of Economy and Finance under Tax Tribunal. Is that so?
Clearly, it does say Ministry of Economy and Finance because, yes, we are part of the Ministry of Economy and Finance. But what I am telling you is that since it is an administrative tribunal, the law establishes that we have functional independence. Yes, we do depend administratively of the ministry, but there is independence.
As the liaison between, apologies. Is it correct that you're serving as the liaison of the Tax Tribunal with the Ministry of Economy and Finance?
I do not understand the question. What do you mean by liaison?
Let me be more specific. When it comes to your administrative functions, you're reporting on those matters to the Minister of Economy and Finance, right?
A ver,
Let me see. What is it that we report back to the Ministry of Economy and Finance? We have an operational institutional plan that includes general goals for all of the public sector. That is reported. That is the only thing that we report to the ministry, or let's say we request an update of the IT system that is reported to the Ministry of Economy and Finance.
You, a question earlier, you replied that your position is one that is called in Spanish cargo de confianza. Do you recall that?
Yes, I told him that it was a trust position, but that currently there is a confirmation process that has not taken place. That's what I said, right? I'm saying that because I was appointed. Yes, it is true, I was appointed.
Confianza also means that the Minister of Economy and Finance could remove you without cause. Is that right?
It could be, but now, as I said before, there is a confirmation process that has not taken place yet, but there is a process that has been established and that has been issued for the president and also for the administrative vocales.
Well, we are less interested in now. What we are interested in is 2013, for instance. In 2013, your position was one of cargo de confianza, where the Ministry of Finance had the authority to remove you without cause if she or he deemed so fit.
Yes, as in any other trust position, yes.
And we were talking about Ms. Ursula Villanueva, and I'm going to come to her later, but her position was also one of cargo de confianza, right?
Yes.
So the same would hold true for her. She was reporting to you as the president of the Tax Tribunal, right?
Yes, she was president's law clerk. Clearly, she reported to me. That's the way it was established.
She had a cargo de confianza. You could have removed her without cause. You had the authority to remove her without cause, right?
Yes, it is not what what usually happens.
Yeah, you had the authority to. I know you didn't, but you had you had the
Pero
authority.
no
to.
entiendo, no entiendo realmente.
But I do not understand your question.
In your direct, you listed a number of functions that you had as the president of the tax tribunal. I wrote them down in Spanish, and I don't want to translate them now, but is it fair to say that none of those functions involves deciding cases before the tax tribunal, with the exception of your role as the presiding, as the president if there is a plenary chamber?
A ver, sí, estoy plenamente.
Yes, I totally agree with you if I understand correctly. So, as president, I do not decide. I do not make any decision of the resolutions in the chamber. I only work with the plenary chamber. Yes, there I do see it. If that's what you're trying to ask me, is that what you asked me?
In your function as the president of the tax tribunal, you cannot interfere in the decision of cases that are pending before chambers. Is that right?
Por supuesto, no puedo.
Of course, I cannot interfere.
So let's discuss the royalty cases of Cerro Verde. Is it correct that the 2006-2007 royalty case and the 2008 royalty case were the first cases before the tax tribunal that involved the new royalty law from 2004?
Yes, I think it was one of the very first cases.
Well, I think in the SMM case, you told us they were the first cases that involved the royalty law. Is that still your recollection?
Yes, but of course, I think it was one of the first cases. Clearly, I do not have that fresh in my mind, but if it was not the first one, it was one of the first ones.
And at the time, the 2006-07 and 2008 royalty cases were pending. Let me reformulate that. You were aware that the 2006-07 and the 2008 royalty cases were pending before the tax tribunal.
A ver, no.
Let me see. I do not understand. There is a timing issue here because I may know that something is pending when they are ready to be decided. I don't always know what is still pending to be resolved.
2013, you were aware that the 2006-07 and the 2008 royalty cases were pending before the tax tribunal.
In 2013, yes, because I was told.
Described the two royalty cases of Cerro Verde as particularly controversial in your witness statement. You remember that?
Yes, I do recall that.
Can you explain to us why you thought that the two royalty cases were particularly controversial?
Let me see. What I recall, what I said the time before clearly because of the especially controversial issue is that I was referring to the various case files that have different matters to be resolved. For example, some of them have to do with sector laws, different issues. So that's what I was saying in particular when I said that they were controversial. They could also be called especially complex or whatever terminology you deem appropriate. But that's what I was referring to. There are some complex case files, others that are less complex, and others that are simple. Our IT system establishes already the case files that are complex because whenever they are classified at the level of the technical office, the descriptors are attached, and then they determine which ones are complex, which ones are less complex, and which ones are simple. That is what I was referring to.
Would it be a fair way of describing the two royalty cases as involving large amounts of money compared to other cases before the tax tribunal?
I do not know the amounts, but it could be. Yes, it could be.
Realmente lo-
In general, the most complex cases, yes, they do contain more amounts in arrears.
When I asked you whether you knew whether the cases were pending in 2013, you answered that si me lo hicieron saber. If
They told me so.
it, who would have let you know about those cases?
I don't understand your question. I'm sorry.
Asked you about whether you were aware in 2013 that the 2006 or 7 and the 2008 royalty cases were pending. You said, if they let me know about it, si me lo hicieron saber in Spanish. Si me lo hicieron saber. And
lo que
who
acabo de decir.
That's what I see. That's what I just said.
wanted to follow up on that and ask you, who is they? Who let you know about it?
The vocal, the member who was handling the case.
In your witness statement, you also mentioned that there were lists of the important cases pending before the tax tribunal that involved large amounts of money. Do you recall whether those two cases were included in one of those lists?
In which statement did I say that?
In your second declaration.
Si me la puede mostrar, por favor.
Could you show me, please?
It's in paragraph 64 of the second declaration. Maybe we
No
on
la
the
puede
screen.
poner en.
Yeah, we're going to put it on the screen. If
Sí.
it's also in your tab. If you look at the small, it's in both of your binders, but probably the more comfortable one is the smaller one. If you look in your
No, prefiero leerlo.
second statement.
I prefer to read it.
And I wanted to point your attention to the last sentence, which says in English, let me see whether we have it on. Can we also put on the next page? Yeah, like this is good. Accordingly, the lists were means by which the tribunal could accelerate the adjudication of certain cases on the tribunal's list of case files. Do you see that?
A ver,
Let's see. In principle, it was a statement by Mr. Estrada, who spoke of certain lists that were drawn up to rule in favor of Sunat. And what we have responded is that we don't draw up lists so as to be able to rule in favor of Sunat. No, we are guided by goals and objectives. And what was presented, well, there was a list of cases which spoke of seniority and the amount of the debt. Why? Well, I have said we are guided by goals and objectives. When we came in 2010, we had a case backlog that was huge. We had about 30,000 cases. That's why the specialized chambers were begun. The backlog was reduced, and we began to see the question of the main controversies. Why? Well, it was being said that we were resolving the easy cases, but not the difficult ones, not the complex cases. So we saw that there were some big and old cases, and that list that is mentioned speaks of seniority and the amounts in controversy, because it's a case management approach. That's what we're doing. Now, what that gentleman who has never had a managerial experience, he's a professional who came through the tribunal, well, there's no major, that's not really right. Obviously, I need to look at the statistics of where we stand and manage on that basis. So we are managing for the main or larger controversies to be resolved as well, but in no way for them to be resolved in one way or another. Moreover, we send a table indicating that the main controversies tend to be more favorable to the taxpayer than to SUNAT. The thing is that when we say that they're especially controversial or especially complex, well, the case files need to be reviewed carefully to make sure that no point is omitted, nothing to be called into question, so that the decision can be defended, because at the end of the day it's going to be challenged either by the taxpayer or by the administration. Oftentimes we've also been questioned by the administration. They've gone to the judiciary, they've gone even to the Constitutional Court, because of decisions that have not been favorable to the administration, but rather to the taxpayer. And so the situation is the same.
You mentioned the goals and objectives of putting the cases on that list. What are those goals and objectives?
Well, let's see. We have output goals, backlog reduction goals, and also goals when it comes to looking at the main controversies. Why? Well, there are specialized chambers initially. Since there were so many cases, we had to set up 2 chambers for municipal taxes. They were smaller cases, but they were a huge part of the backlog, and so that was reduced. Once that's reduced, let's look at the backlog of the heavier cases, and that involves SUNAT. We look at cases that come from municipalities nationwide, cases that come from SUNAT, customs cases as well, and cases from other smaller administrations. And so we need to see to it that everything is moving forward. At this time, we have reduced the municipal taxes to a single chamber, and they're up to date. We're no longer bothered by the backlog. Customs is also up to date. So we are focusing on cases involving SUNAT. And with SUNAT, one has to look at the major cases. In 2010, we saw that major cases were beginning to be resolved. And that was also a complaint lodged by the taxpayers, because the taxpayers are saying, my case isn't being resolved. The easy ones are being resolved, but you've not got to mine.
And in your direct, Ms. Olano, you said we follow goals and objectives, and based on that we assign case records, and we also resolve those case records. So are you saying that you assign case records to chambers based on those goals and objectives that you just explained?
Let's see. Let me explain. The assignment is random. The cases come in, and they're assigned every 2 weeks, except for the urgent ones. There are some cases that have much shorter time frames, say a closing. Those are assigned on a daily basis, or cases that have to do with performance. What are we saying? Well, that we're saying when it's already gone to the administration and it comes back, and one needs to issue a decision, or it comes from the judicial branch and we need to resolve it in the short time frame that the judicial branch has indicated. Normally, they're assigned on a random basis every 2 weeks. That is the assignment. And what do I say based on goals and objectives? Well, it goes out based on the specialized chamber ways. There are chambers for municipal taxes, as I was saying. Now there's one, the chamber for municipal taxes, for customs taxes, those that look at SUNAT taxes. There's some that look at the Lima region, and others, IPCN, which is the main intendancy for national taxpayers, and Lima as well. That's how they're determined. And that's why I was telling you that it's in function of the goals and objectives. Each specialization has a goal and objective, and they're different ones.
Off the text room. Let's move on to the Cerro Verde royalty cases. So there were several Cerro Verde royalty cases before the tribunal. Now, once a chamber renders the first decision in one of those cases, is it correct that the other chambers that are hearing Cerro Verde royalty cases have the following choice? They could either follow the same criteria that is set forth in the first decision, or if the vocal disagrees with that criteria, the vocal ponente, that vocal ponente could request that the case be brought before the plenary chamber of the tax tribunal. Is that a correct description?
Yes, let's see. The tax tribunal also has a function of ensuring uniformity of criteria. So when a chamber resolves a case, and then another case comes along with the same situation, it will either decide in the same manner, or it will not be in agreement with how it was decided. If it's not in agreement with how it was decided, then it has the power to bring it to the plenary chamber in order to request a change in criteria. We don't know the outcome, but they do have that power. Was that your question?
Thank you. And the plenary chamber is comprised of 33 vocales and yourself, right?
At that time, yes, it was 33 plus myself. I'm also a member of the plenary chamber.
In 2013, right? In 2013, there were 33 vocales and yourself in the plenary chamber, right?
Yes.
If the plenary chamber took a position and took a decision on a particular case, it would then be binding on all subsequent royalty cases.
Yes, if the plenary chamber adopts a position or a criterion, it is binding for future cases.
So in other words, the first chamber that would decide the Cerro Verde royalty case would have the advantage of deciding it according to its own criteria without having to face that dilemma of having either to adopt the criteria of a previous chamber or having to put the case in front of the entire plenary. Is that a correct description?
It's not exact what you're saying, because actually, well, I would not speak of an advantage. Each vocal manages their cases, so each one sees at what time what moment they're going to decide it. The ideal thing is that when there are similar cases, that they coordinate. But it's not that one has an advantage, obviously. It could be in various situations that a criterion has already been adopted, or there might be one that has been adopted in the past, and that the vocal is not in agreement, and so it brings it to the plenary chamber in order to change the criterion or the position because they believe that is called for, and then the plenary chamber takes a look at it and they see whether or not they agree with that vocal. That is how it works.
Let's take a chamber that the second chamber that decides a royalty case of Cerro Verde. It faces the situation that the first chamber has rendered a decision that employs certain criteria, and it now can either follow those criteria or it has to go to the plenary chamber and has a decision taken by the entire plenary, right?
Are you talking hypothetically or about this actual these facts?
Hypothetically, let's take the hypothetical royalty case. There are a series of royalty cases. The second chamber to render a decision already faces a decision by the first chamber that has certain criteria. So it can either adopt those criteria or it can go to the plenary chamber and have the entire plenary chamber vote on the decision. But it cannot on its own take different criteria, right?
It is not correct because independently they make a decision independently. Now let's take the hypothetical. A criterion was adopted, and then there's another chamber, and I can tell you this because I worked in the chambers as well, and there's not agreement with the criterion. The first thing they need to look at is whether they are in agreement or in disagreement, because they may not be in disagreement. If there is agreement, then they'll adopt the same criterion. If they're in disagreement, then they're going to decide to take it to the plenary chamber. That's how it works. But the first thing they have to do is see whether they agree or disagree in a hypothetical case. And in the specific case, here there was no disagreement, and that's why the matter was not taken to the plenary chamber.
Hypothetical, and you just confirmed that the second chamber cannot take, if they disagreed with the criteria of the first, they cannot by themselves issue a resolution with different criteria. They have to take it to the plenary chamber, right?
That's right. Because when it goes to the office, we need to double check whether there's any observation of that would be a dual, and the code suggests there needs to be uniform criteria. So we make an observation. Now, if there's a dual criteria, and when I say we, it's not me, it's the technical office. But the technical office makes the observation. I take a look at it, then it goes to the chamber, and there the chamber evaluates, and in any event, if they want to take it to the plenary, they'll do so.
The first chamber to render the decision does not face that situation because it itself, let's assume in our hypothetical, there are no pre-existing criteria. It itself decides a case either in favor of Sunat or in favor of the taxpayer. It sets its own criteria, and whatever those criteria are, it does not have to follow a previous decision, and it also does not have to go to the plenary chamber when it renders its decision, right?
Yes, that's what normally happens. A decision is adopted, it goes through the technical office. If there's no observation, then it is issued.
So let's look what happened specifically in the Cerro Verde royalty cases and who got to render the first decision and who got to render the second decision. And for that, since we're going to mention a number of names of vocales, we have prepared a demonstrative that we put here on the screen and that we can also distribute in hard copy. And that shows the two chambers involved in the 2006-07 and 2008 cases. So if you can confirm that the 2006-07 case was pending before Chamber 10, is that correct?
Yes, it is.
2008 royalty case was pending before Chamber number 1, correct?
Yes.
Here the names of the vocales sitting in those chambers in the year 2013. To the best of your recollection, is that does the demonstrative have an accurate representation of the names of the vocales that were in those two chambers in 2013?
Yes, that's correct.
So in chamber number 1, the vocal, the president of the chamber and the reporting vocal ponente, was Miss Lisette Zuniga Dulanto, right?
Yes.
And in chamber number 10, the position of president and reporting vocal did not coincide. The president of the chamber was Mr. Carlos Mariano Valdivia, right?
Yes.
And the vocal ponente was Luis Cayo Quispe, right?
Yes.
The 2006-07 case was filed in May 2010. Do you recollect that?
It was filed. I'm sorry. You're saying a session was held?
Verde filed the 2006-07 case before the tax tribunal in May 2010, right?
I don't actually remember the date of when the appeal came in. Is that when what you're talking about, when the appeal came into the tribunal? I don't remember. What I remember from the last hearing is that there was an oral report before May, so it must have come in before then.
I present to you that it was filed on the 12th of May 2010, and that's in Exhibit CE 40 in your tab 17. We don't have to go there, I just say this as a reference. The 2008 royalty case was filed 9 months later on 10th March 2011. And again, I represent it to you, and it's in Exhibit CE 49, tab 19. You mentioned at the SMM hearing that Mr. Cayo, who was the vocal ponente of chamber number 10, requested the file of the royalty case in 2011, right?
Yes. According to the information system of the tribunal, yes.
Would you agree with me that when a vocal ponente requests a file, she or he typically does so because the vocal was to review the file, wanted to review the file?
I understand that, yes, and that's what I also said. For, according to the way the system works, Vocal Cayo asked for the record in 2011 before it was in the archive to be delivered. That's what it's called. So normally when they ask for the file, it's because they're going to review it. Now, whether or not he reviewed it, that I don't know. I have no way of knowing. All I have is what the information system says, which is that it was asked for in 2011.
On 6 March 2013, Chamber number 10 announced that it would hold an oral hearing, right?
Well, according to the latest action, I don't recall the dates so well. The oral report was it must have been in March. There must have been the parties must have been given notice that's about the date.
Look it up. It's Exhibit 79 in your tab 22. There was on the 6th of March that Chamber number 10 announced that there would be a hearing in the 2006-07 case on 5th of April. Do you see that?
Sí. Cuando habla.
Yes, when you say announced, you're referring to the notice, right? Because that's the notice to the taxpayer. There is no announcement, a public announcement, but rather the notice is given.
And would you agree with me that once vocales go to an oral hearing, in most cases they would already have a preliminary draft of their decision?
Let's see. I recall very well what I said the last time. And ideally, when there is an oral report, there should be a draft at least. If there's not a draft, and I have no way of knowing that, then there is at least an explanation by the vocal to the other members, the other vocales, about the case, because there's going to be an oral hearing where one is going to hear from the parties, and one goes into the hearing well informed about what it's all about, so as to be able to better understand what the parties have to say. That is what I said.
Now, chamber number 10 was the first one to hold the oral hearing. Is it typical practice of the tax tribunal that the chamber, isn't it the typical practice of the tax tribunal that the chamber that was first seized with a particular case would decide the case first?
I'm sorry, I don't know what you're referring to.
Isn't it typically the case that if a chamber is first seized with a case, if there are a number of cases, such in the royalty matters, the chamber that's first seized with the case would first render the first resolution?
Let's see. The thing is that there are different chambers. Each chamber manages, and I have no way of knowing that. Each one determines the investigative steps, the oral report, and what they do in their own timeframes. There may be a chamber that, even though there's been an oral report, may take more time. One might or might not take more time, and I cannot know that. What I said is that normally, or what should be, is that in an oral report, there should be a draft, or at least they should be familiar with the issues. And I say this based on my experience, for I too have been a vocal in a chamber. That is the situation now. What actually happens in reality, that I cannot say. Now, it's not that there is a exact first one in is first one resolved. That doesn't exist. It depends on how the given vocal or how the given chamber handles their cases. There are some who work more quickly. There are others who do not work as quickly. So it depends on them.
We can agree that at least with regard to the 2006 or 7 case, that was the case that was first filed of the royalty cases, and chamber number 10 hearing the case was the first chamber to schedule an oral hearing for a royalty case, right?
It scheduled the oral report, but I don't see how that's relevant. Yes, it did schedule the oral hearing, the oral report.
Okay, so they scheduled it on March 6th. So let's see what happened with the other case, the 2008 royalty case. So in the 2008 royalty case, in March, after chamber number 10 scheduled a hearing, Miss Ursula Villanueva starts working on a resolution for chamber number 1. Is that correct?
I'm sorry, what's the date that you said?
I was saying that after March 6th, after chamber number 10 scheduled a hearing for the 2006 or 7 case, Miss Ursula Villanueva starts working on a resolution for the 2008 case that is pending before chamber number 1, right?
I could not tell you the date. What I can tell you is that she began to work on the case with vocal Zuniga. The exact date, I don't know.
When I come back to the fetcher, let me ask you still a few questions about Miss Ursula Villanueva. So I think you already mentioned that she was your advisor. So if I understand correctly, you had one such advisor and you had one administrative assistant, right?
Yes.
And Ms. Ursula Villanueva was your advisor, right?
Yes.
And her function was to assist you in conducting your various functions that you had at the tax tribunal.
Yes, well, she would issue technical reports. She would carry out several tasks in coordination, and during that period, I was in several places. She was entrusted as necessary as one to resolve complaints. She was in charge of the technical office when no one else was there, and she also helped in the chamber when necessary.
You follow your line of questions just in order to understand better the chronology. Buenos días.
Good morning, Ms. Olano. When was Ms. Villanueva called to work in Chamber 1?
No recuerdo bien. Debe haber...
I don't remember the date so well. I think it must have been in March, which is when the vocal ponente and Luisette Zuniga was convened. Is that the date of the email that you brought that is here approximately? It must be approximately because as of that date she was working on the case, apparently. I don't remember the exact date.
And you had assigned Ms. Villanueva to other cases? She supported different chambers. Had you assigned her to other files in specific cases? When other chambers have asked for my support, yes. When it was required from other areas as well. Unfortunately, we were short on personnel. We don't have any document in connection with the request by Ms. Zuniga or your instructions. You said everything was done verbally. No, I don't have an email, no. In the cases in which Villanueva had been involved before, let's see, she was involved before in other cases, right? She provided support in other cases, yes. In those other cases, did she liaise with you in connection with the case file? No. She provided support in the chambers, and then she had to work with the vocal ponente. But she knew that she didn't have to have any relationship with you in the case file. Yes, she knew that perfectly well. And she had done so in other cases. Yes, she provided support in other cases. Now, what about this email? Read the arguments and then we can talk about it. I don't know what she was thinking, really. Simply, I think it was a concern of hers, and that's what I've stated. I don't know exactly what happened to her and why she stated what she stated. Was it striking to you? Perhaps you could have said, okay, that's not my position to intervene, etc. The only thing we saw is your email. Well, yeah, I just saw a formal reply, received, and she knew perfectly well that I am not involved in those cases. She knows that. She knows that, but it says here, read the arguments and we can talk about it after having intervened in other cases. I cannot answer that question. I do not know what Ursula Villanueva wanted. I imagine that this is a concern that she had to work on in this case file in a proper manner. She was entrusted with it. Thank you.
Questions that Professor DeWille asked. So first of all, you mentioned that Ms. Ursula Villanueva was regularly assigned to chambers to assist as an asesor suplente. You have not presented a single email that would show that Ms. Villanueva was assigned to another chamber, did you?
I have not submitted emails because I have not found emails. These are old emails. I can indeed say that she had provided support to other chambers. I didn't say regularly. She has provided support to other chambers when we're short on personnel. In that context, in 2013, we were short on personnel, and in my statements, I submitted all of the memoranda that showed that we were short about 30 professionals. when we were short on personnel and somebody needed support and there was no other professional available, then I had to allocate the professionals we had at hand. And more so in large and complex cases, because she had that experience, right?
Olano, you had to produce the emails, all your emails, from the relevant time period here, 2013, in response to a transparency request, didn't you?
Yes.
So you had the emails from that time period, right?
Let's see. The emails that were requested via the transparency request had to do with a long period of time. We, and I say we, okay, but it was the General Office of Technology and Information, the one that was asked to help. Well, we asked to back up all the information and to provide all of the emails that they found in the computer. And that was asked after a certain time went by. So I don't know what may have happened because sometimes they change the computers and they format them. But the General IT Office was asked to conduct a search and look at the backup information. I don't know the technicalities of it all, but they were asked to look for all of the emails on the basis of the transparency request. The transparency request indicated a specific set of addressees, a specific period of time, and that is what they found, and that is what they provided.
So that Ms. Villanueva was appointed to other chambers. You produced a couple of emails that show that law clerks from other chambers were appointed to different chambers. You found those emails, right? But you did not find any email in your collection in which Ms. Villanueva was assigned to any chamber as an asesor suplente.
I showed those emails as an example of how we managed resources. And that's not all the supports that we've had. Those were the ones that we were able to find. There were other supports that were provided to other chambers that we haven't found. I haven't found them.
Solano, the 2008 resolution has Ursula Villanueva's initials on it. If you wanted to show us that Ursula Villanueva was assigned to other chambers, you could have given us resolutions that have her initials on it, but you didn't produce a single resolution, other resolution in the 2008 royalty case that has Ursula Villanueva's initials on there, probably because they don't exist, right?
In principle, I have not conducted that search. In this case, we have the initials, and that's a matter of transparency, right? It shows that she participated in that case. Not all of the chambers put their initials there. That depends on the style of each of the chambers. If you tell me that I have to find resolutions with the initials, I didn't conduct that search. I don't know exactly what you're trying to refer to.
You wrote in your second report several paragraphs on how Ms. Villanueva was assigned to other chambers. You did apparently a diligent search because you came up with other emails, although they don't relate to Ursula Villanueva. So you clearly searched. And isn't it the case that you just didn't find any other resolution and any other email that would show that Ms. Ursula Villanueva was ever appointed as an asesor suplente to another chamber?
Let's see. If I haven't shown them, it's because I haven't found them. These are old emails, as I said. And we don't have all of the emails from the law clerks, every single one of them. No, I've shown the ones that I found. I remember very clearly that she provided support to other chambers. I have not submitted the emails because I haven't found them.
There's no evidence of that other than your statement. You also have not presented a single document that would show that Ms. Zuniga requested you to have Ms. Villanueva as her asesor suplente, did you?
Bueno, por como
As I said last time, the requests could be telephonic or oral. At the time, we were all in person. We were sitting in person, so I didn't really have to submit emails that I didn't even know or don't even know whether they existed or not.
Just to confirm, Ms. Olano, you have access to all the resolutions, right?
Let's see. I do not have access to all of the resolutions. Why? Because once the chamber hands down its decision, when the decision is sent out, then it is put into the system and then it is placed on the web page. That's what happens.
President of the Tax Tribunal, you don't have access to the resolutions of the Tax Tribunal, Ms. Olano? Is that what you're saying?
I have access to them after they've been issued. Is that the question?
Ms. Olano, I'm not asking you about tax tribunal resolutions that are pending right now. We're talking about the past 10 years. While we're talking about the time period in which Ms. Villanueva was your assessor. During that time period, you have access to the resolutions that were issued during that time period. And sitting here today, can you name us one other resolution that has the initials of Ursula Villanueva on it?
No, I don't have that committed to memory to determine whether there's a resolution that bears the initials of Ursula Villanueva.
Let's look at the email that we have here on the screen. The email is dated March 22nd, right?
Yes.
And that was about more than 2 weeks after chamber number 10 announced that it would have an oral hearing at the beginning of April, right?
According to the email, it says announced here. If there is a notice, it is sent to the parties. It is not a public announcement. It's not that we all know that an oral report will come to being. The party knows it, the administration knows it, the taxpayer knows it.
You would agree with me, on 6th of March, chamber number 10 notified the parties that it would hold an oral hearing at the beginning of April, right? And this email, we can agree on that, is more than 2 weeks after that date, right?
'22 March. Yes, okay, I'm looking at the email.
That on that email, there is no mention of Ms. Zuniga. She is neither copied on the email, nor is that email directed to Ms. Zuniga, the president and vocal poniente of chamber number 1. Right?
Not in that email. What else could have happened? Oh, I don't know. The email was sent to her. It's not in this email.
It's not copied on that message, right?
Not right here is what I see on the email. If it was sent later, I don't know.
And is there any reason we only have your reply and not the original email from Ms. Ursula Villanueva to you?
As I explained to you before, when there was this request for transparency, the request covered quite a long period. They looked for emails during quite a long period, and we asked the IT office to provide support for the IT office to look at the backed up information and to extract all of the emails. And that is what the general IT office did. They extracted all of the emails, and that's what they found.
Ms. Olano, you told us last time that you reviewed the emails and you were withholding emails on what you said were for personal information. Isn't that right?
Yes.
Sí.
And we have a total of 9 emails from you that relate to the 2006-07 and 2008 royalty cases. They're all from your outbox except of one. Is there any reason that you did not provide emails from your inbox, with one exception, but only from the outbox? Did you withhold emails that were in your inbox and forgot to check your outbox?
Again, this was an old period of time. Somebody assisted us from the IT office. Of course, I wasn't able to look at all those emails. I was responsible. These were emails to me. I was the addressee, so I asked for all the backed up emails, and that is what was found. The email messages that were found in my machine. I said that this is an old period of time. So computers have changed as time went by. Computers have been formatted. I don't know if all of the emails were there. We have provided what was found.
Here again today, what you told us at the SMM hearing, that you were withholding emails that were not produced.
Por el tema.
Health related is what I said. It was health related.
Ms. Olano, you personally made that selection, right? You determined which emails relate to what you say health, right?
Let's see. When I say that I did it, it's because I was the person responsible for that. They were asking for the emails from the president of the tribunal addressed to the vocales and addressed to other addressees, and they did that for a given period of time. We're talking about a large number of emails. I don't know. The period covered 5 or 6 years. I don't recall exactly. And then there was a brief period of time for us to provide the information. I couldn't really afford to look at all of these emails. I was responsible. That's why I said I. But in the transparency requests, it was sent also to the office.
It's a very specific question. We're going to go on the whole day if your answers are more precise. So try to be more precise. Your counsel can then ask you follow-up questions to elaborate, but we need shorter answers from you. My question was, did you withhold emails that were responsive to the request? Did you or did you not? Did you personally select emails to withhold? Yes or no?
I did not provide emails related to health-related matters. As I said, perhaps not 100% of those emails have not been provided.
You were to withhold or not, that were withheld or not. Did you personally select them? That was my question, and I want an answer to that question.
Los seleccioné.
I selected them with an IT assistant. That's the exact answer. I had done the selection with an assistant.
Is it a coincidence that all the emails we have from you, which are on these matters, which are not many, that they all come from your outbox except of one?
I cannot answer that question. I haven't looked at the inbox or the outbox. What was found was provided and delivered, and that's that. I cannot say whether this is a coincidence or not. I don't know. I have tried to explain to you in all manners possible that this happened long ago and that the emails were delivered. And when I said that I was the person responsible, well, I delivered those with the assistance of an assistant. Obviously, I cannot do all that search myself.
Let's take this concrete email. So, Ms. Olano, what you're telling us is that the email with the attachment that Ms. Villanueva sent you got lost in the course of time, but that your response, which doesn't have the attachment, was still in your outbox. Is that what you're telling us?
Sorry, could by the mail for the record.
Yes, I'm talking about Exhibit CE 648, which is the March 22 email.
Is that the one on the screen?
Let me ask the question again. With regard to CE 648, is it your testimony that the email from Ms. Villanueva, which had attachments on it, got lost in the course of time, whereas your response, without the attachments, happened to still be in your outbox? Is that your testimony? Fully not submit the first the first email and forgot about checking your outbox. Which one of the two options is it?
I state what I already said. That I reviewed all of these email messages with the assistance of specialized personnel from the IT office of the MEF. And that is what was found, and that is what was provided, and that is what I state.
Alan, in this email, Ms. Villanueva tells you that she's sending you the arguments of both sides. You see that?
I do.
Arguments of both sides here means arguments made by Sunat and by Cerro Verde in their submissions to the tax tribunal in the 2008 royalty case, right?
I assume that that's the case, yes.
Villanueva also tells you here that she's sending you the main clauses of the stability agreement, right?
Yes, that's what the email says.
There are good arguments for both sides, but she was leaning in one direction. So, Ms. Villanueva, you surely understood Ms. Villanueva here as having assessed the merits of the 2008 royalty case, right?
She must have, I don't know.
Analyze the arguments of both parties. Ms. Villanueva must have had the case file in her office, right?
Probably. Otherwise, how else was she going to provide support to the chamber?
Office was not at chamber number 1. Her office was next to yours, right? Across the aisle.
Are you asking if Villanueva's office was across from mine? Yes, it was across from mine.
Please read the arguments when you can, and we can talk about it. You see that?
Sí.
Yes, I do see that.
So she wanted you to review the arguments, and so you understood that as her wanting you to review the arguments of the Cerro Verde case and to have a conversation with her about it, right?
I cannot say what she wanted. I am not able to know what she wanted. But what I said is what I said before. The concern was to say that good work was being done.
And in your first witness statement, you say that your response was a solitary thank you, right? Do you recall that?
Yes, yes, I do recall that.
But that's not really her response here. Your response here. I mean, what you said is okay, thank you, right?
I don't see the difference, really. In my opinion, it was solely a thank you.
You means that you agreed with her suggestion, didn't you?
That is your presupposition, but to me, it was simply a formality.
You didn't tell Ms. Villanueva that it was inappropriate to discuss cases with you, did you?
As I said, she knew that I did not intervene in cases.
She wrote you that email. So you didn't reply like Ursula. After 10 years of working in the tax tribunal, you should know that you cannot ask me such questions, did you?
Like I said, there was a mere formalistic answer acknowledging the receipt of the email. I receive emails every single day, lots of them, and it was just a formal email. We do not have the attachments. Do you know what attachments were sent to you by Ms. Villanueva? I don't know. I don't have the annexes. Did you not find out later on what those attachments were? No, I have not found out what those attachments were. Thank you. Once the case file, the case is decided, it is sent to the central administration. We no longer have the case file. Well, we're talking about before the decision is made and when this was submitted to the tribunal. When it was sent to this tribunal, to this arbitration tribunal, and we do not have the annexes, I was interested to know what those attachments were. No, I don't have them. I didn't have them. That's why I haven't submitted them. Okay, thank you.
You didn't tell Ms. Villanueva that she should send that question to Ms. Zuniga, right? That's not your reply, right?
Again, I simply provided an acknowledgement of receipt answer. It was formalistic. She knew very well that she had to talk to Villanueva because Villanueva is the one that had to define the draft with the other two vocales that were going to agree or disagree on a certain position.
You did not know that. You testified that you actually met with Villanueva in response to that email, didn't you?
Let's see. I do not recall exactly. What I did say is that what may have happened, the only thing that may have happened, is that she told her that her answer had to be quite exhaustive. I said this before, to be exhaustive, to look at both parties' arguments very well, and to prepare a good draft so that the tax tribunal members can assess the situation and discuss the situation.
This statement. Let's pull up paragraph 49. That's in tab 1. And you can also look at it in your binder. So you said this email simply indicates that I met with Ms. Villanueva to recommend to her that she be exhaustive in the research preparation of the legal foundation for the decision in the 2008 case. You see that?
Sí.
I do see that.
Ms. Solano, you told that Ms. Villanueva worked already for a long number of years at the tax tribunal, that she was before a legal clerk in various chambers, that she headed the technical office of the tax tribunal. At that time, she has been working at as assessor for a number of years. You think you had to tell Ms. Villanueva that she needs to be exhaustive in her research and prepared a legal foundation for her decision? You're telling us Ms. Villanueva didn't know that you needed to tell her that?
Yes, because this is just a recommendation that I always give. It's not too much. Regardless of how good she is, she could be a law clerk very well, but you have to give her recommendations. These are very large files, and we know that once a decision is made, a challenge will be placed, whether the taxpayer or the administration. So the decision has to be well-founded, regardless of the position adopted. It has to have good foundations. As I said before,
I have to wait for the translation. So, Ms. Rolana, you testified, and tell me whether you still agree with that. You testified in the SMM arbitration that Ms. Villanueva had great technical skill and experience. Is that still your view?
yes.
You testified that Ms. Villanueva prepared high-quality draft resolutions. Is that still your view?
Let's see. What I have said about her is that she is a well-prepared professional, that she started very young at the tax tribunal, and then she went to the private sector. She conducted studies. She worked for other institutions and came back to the tax tribunal. Yes, she is a well-prepared professional. That is what I've said.
And yet you still needed to her. You're telling us that the purpose of the meeting, after Ms. Villanueva asked you to discuss with her the Cerro Verde case and the arguments of the parties, your response is that when you met her, you told her, please draft a thorough decision. Is that still your is that your testimony? Notwithstanding that Ms. Villanueva had all that experience in drafting decisions already, and you described her as being very thorough. Is that what you're telling the tribunal?
Yes, because a recommendation is never too much. Even when you talk to a vocal, I was in the chamber, and we always knew that this is a recommendation that is never too much. The fact that it is a specialized law clerk, it doesn't mean that I cannot make a recommendation that bears in mind all of the items. Otherwise, there wouldn't be a resolution whenever there is, for example, a request to expand or elaborate on the grounds. And in that case, these are specialized vocales, and please do not make a recommendation in that case. But in some cases, we do get a request to provide more evidence, and they are specialized professionals, but sometimes they miss something. So the recommendation is never too much, in my opinion.
You didn't tell Ms. Zuniga that she had to draft a thorough decision, did you?
A ver,
I didn't tell them that they had to draft. She had to support the vocal, because the draft of the final resolution will be something seen by the vocal ponente. She may prepare a draft. She may analyze the background to support. She may have, if there are two positions, one position, whatever it is, to look for all of the grounds for the vocales to be able to discuss and define. But the party that will look at the final draft of the final project will be the vocal ponente. That person will say yes or no, follow that path or the other path, because that is that is the party that needs to support, because the ones making the decisions are the vocales.
So short. I know you want to speak long, but you have the chance to do it afterwards. Keep the answer short. We need to move on. You also testified that one of your obligations was to ensure that chambers that had similar cases pending coordinate. Do you recall that correctly?
Sí.
Yes, that's what they should do.
With me that in March 2013, while Ms. Villanueva was working on the draft resolution for the 2008 royalty case, you did not inform Chamber number 10 that Ms. Villanueva was working on the draft resolution.
Es que eso a mí no me corresponde.
That was not what I had to do. What I said is that whenever there are similar pending proceedings, the vocal is the one that has to do that, not myself. I do not need to participate in this. I am just a liaison. I am told, look, such and such a vocal is looking at the same thing, and I may say, okay, coordinate, or I may say, yes, they're looking at the same topic, but I do not need to report to another vocal and say that someone is doing something else. They are the ones who coordinate between chambers. I would like to ask you, within the tribunal, there is collegiate work, and therefore it is logical that the vocales and those who participate in decision-making may have some sort of communication, because at the end of the day, there is an action in solidarity. So my question is, within the tribunal, are there any rules preventing that type of communication, or quite the contrary is the rule? If I understood correctly, in the room, the vocal ponente prepares the project and clearly discusses this with the vocales, or explains the vocales on the contents of the project, because at the end of the day, the three would need to make a decision. A resolution comes to fruition with 2 votes. There could be a dissenting vote, but you need 2 votes to have a resolution. So there needs to be support, and also it has to be a reasoned resolution. But that is not my question. As president, you said you have to coordinate even the activity of various chambers, and to coordinate, you need to have some sort of information from the 3 vocales, or one of them, or whoever it is, with the president. So, leaving aside this case, in other cases, is this the norm? Yes. Sometimes the vocal tells me I am looking at a case and there is another pending case, or sometimes at the technical office there are 2 cases. So let's say 2 cases with similar situations. So whenever we have that, I say, why don't you coordinate with the other vocal? Why don't you coordinate with the chamber? I am sort of a liaison, a link in between chambers, so that they can coordinate their position, or if something that has to be dealt with a plenary chamber. I do not understand the scandal behind the email from Ursula Villanueva asking you, because Ursula, at any rate, is advising Vocal Zúñiga, and within the tribunal, whether it is the vocal or the assistant, it is logical for them to coordinate with the president. This that may seem normal to me doesn't seem to be for the tribunal. Is it the way it works, or there are some ethical rules that maybe prevent you from doing that? Let's say that usually there is support staff that coordinates with the chamber, with the vocal ponente that is looking at the topic, not with myself. I am not the one that is in charge of decision making. And in my opinion, or my opinion would not be valid either, because at the end of the day, you have 3 who make the decision, 3 who will see whether they agree or not. So that is what usually happens. That is, there is coordination with the vocal ponente. But if there is a complicated case, such as this one, there might be consultation, or they may make some comments because at the end of the day, the resolution to be made by the three vocales might entail that it is a complicated case and that they may need some sort of information that is part of the solidarity that the tribunal may have. Is this the rule? This is not what we usually see, but whenever there are plenaries, I do participate whenever we have a plenary chamber, when a vocal has something in the case file or a topic that needs to be taken to the plenary. Even though I do not see the case file, I do see the topic that is part of the analysis conditions, and that's how I see the topics, and I offer a position because I also sign. So here, whoever signs has the responsibility. I also sign and I share my opinion, whether I am in favor, against, or whatever it is. In the resolutions, the ones signing are the ones that have the responsibility for the resolution. The law clerk does not have the responsibility because the vocales are the ones who will be defending that resolution, not only in the case of an amparo, but also in the case of an administrative adjudicatory proceeding. So in some cases, the vocales need to defend the resolution. Thank you very much.
Question to Dr. Cremades. It also concerns the assignment of Ms. Villanueva and the email that we now already saw. Do I understand correctly that your testimony was that there was a lack of personnel? You were lacking more or less 30 people, so you had to substitute for law clerks?
Yes. In 2013, we didn't have staff. Even in my statements, you will see all the memoranda sent to the office, the general office of the ministry, requesting hirings, new higher-ups. So in that context, without staff, I was asked for support, and other times we have also had the support from other areas. So if there is a shortage of staff, it is my role to manage those resources, and I need to send an individual wherever that person needs to be. In this case, it was Ursula Villanueva, to send Ursula to that room. And at some point, there was also a complaint office that had been recently created, and there wasn't anyone to make decisions as to the complaints presented. So she also had to go to that office, or also go to the technical office. So let's say that it would have been ideal to have full staff, but whenever that is not the case, the law clerks get moved around to the areas based on the needs, and I think that is part of my role.
At that point in time, in 2013, had chamber number 10 a law clerk, or were they also short of staff?
They did not request a law clerk. Whoever the vocales ponentes were the ones who requested the law clerks. So based on my examples, the ones I found, there were some vocales that requested support, and sometimes we sent from the technical office whenever support staff was needed, but it had to be requested. I had to be told. If they didn't ask me, it was because it wasn't necessary, and I do not participate in each chamber. Each chamber sees their own management, but if I am asked for support, I try to see what I do and how I manage that.
And a law clerk, or do you not remember? I heard you saying they have not asked you for a substitute law clerk, but had they one or not?
They had law clerks. I do not know whether they required someone with a higher level, but they did have law clerks.
Thank you, understood. And when you assigned Ms. Villanueva, who was your personal law clerk, to a chamber. This meant you then missed her assistant, right? I mean, it was, the day has only 24 hours, so it was a work allocation decision from your end?
Yes, as I said before, I did not only send her there, I also had to send her to the complaint office whenever it was necessary, to the technical office. Right now, I do not have a law clerk in my office, so in some situations, I do need to look into the issues, and I get the support of the technical office. But whenever it was necessary, we had to do it. There was no other option.
Did you discuss with her, for example, the time budget, how much time she was supposed to be spent on this assignment and the other assignment, and also on your specific assignments, or was she then simply assigned to Chamber 1 for this decision without any further instructions on time budget, duration, whatever?
She was appointed to Dr. Zuniga, Chamber 1, full-time. Once she finished, and once the vocal didn't need her, she would go back to the president's law clerk position.
This I do not yet fully understand. I saw in paragraph 46 of your witness statement that Ms. Villanueva was assigned by you also to other cases in Chamber 1. So how was her time period at this Chamber 1 limited, or how? Because you lost her, so to say, as your right hand, and I just want to better understand for how long you lost her, or wanted to lose her, or gave her permission to not to work for you.
I lost her many times because we also had a shortage of staff also in other areas. So whenever she was not available, I resorted to the technical office. There is a technical office that also helps me. So whenever she was not available, I got the support of the technical office. But whenever she worked there, she was there in the chamber, and then she was also the one addressing complaints in a specific complaint office. And right now, I do not have a law clerk that is, for example, supporting and I get the support of the technical office. That's what I do.
Mm-hmm.
I have a few questions in connection with this. Is there any type of record of the assignments of the law clerks? In the case of the law clerks, there is no record because in general, they have a temporary regime that is called CAS, C-A-S, but they are hired, and based on the number of law clerks in the various chambers, they are assigned. But law clerks may move from one chamber to the other one whenever needed. For example, in some case, we also had the complaint office and we established shifts. But how do you know how many law clerks you have if there is no centralized record? How do you know, for example, if there are 4 in Chamber 3, 5 in Chamber 2? It is not. I guess I didn't understand your question when you said a record. Whenever the chambers are put together, well, you are saying that the chambers are put together, but law clerks are moved from one chamber to the other one. There needs to be some sort of record as to see who is where. Yes, there is a composition of those chambers with the rapporteurs and the law clerks. In the case of the law clerks, we see how they are doing and we appoint them. The administrative vocal sends the chamber composition with the law clerks assigned And I asked you whether, when you talked about a record, whether there was a written document. But this is related to the same thing. For example, I was secretary of the Supreme Court of Justice, which was something similar when I was young. At that point, there were permanent allocations. There were no substitute allocations, as you are saying. But if the justices wanted to know the secretary working for each vocal, that was written somewhere. So how could you know who was working where? The law clerks are established in each chamber. The substitute law clerks are assigned just to provide some support at that specific point in time, and then they go back. So those are not recorded anywhere formally, correct? I do not understand formally, unless they stay for a long time, because there is no advisor, and there would be no record that would allow us to know that the substitute law clerk would be assigned to room 3 or 4 on day 3. Not with substitute law clerks. You wouldn't be able to know that. You also said that, and this was striking, that you could have required a higher level law clerk. Are there different level law clerks? So these permanent law clerks are not enough? Is that what you are saying? What do you mean a higher level law clerk, and who determines, for example, I understand that you thought that Ms. Villanueva was a higher level law clerk. Is that correct? The rooms, the chambers have junior law clerks, the ones that have less experience. You have analysts and you have specialists or experts. So that's what I was trying to imply, those that are of a higher level. What I said is that in that case, it wasn't requested. And Dr. Villanueva was the law clerk that provided the highest possible level. Is that correct? Ursula Villanueva was an experienced law clerk. She was also an expert law clerk. So she had been junior, an analyst, and she was now a law clerk with the president's office. So in your opinion, it was the logical person to be assigned to big cases, and she could be moving from chamber to chamber. Yes, it could have been if it was necessary. You also said, to answer a question by the president, that she worked with Ms. Zuriga for a while. I understand that they worked together on some case files. I understood that she had only been assigned to this case file, but in answering a question by the president, I understood that she was in the chamber for some time. Could you please clarify whether she only worked on Cerro Verde, as I think I read it in writing, or did she also work on other files with Dr. Zuniga during that period? To be honest, I do not recall whether there was any other case file, but Dr. Zuniga requested it for this case file. So it is not that she worked at that chamber for some time, only for some time until the case file was completed. What I wanted to tell you is that during that time she was in the chamber, and then she went back to the president's office. President Olano, I have a question. And please answer by going back to your first statement that you were only going to say the truth and nothing but the truth. In this arbitration, or in this case file, we are discussing whether there was a change in the legal and tax criteria based on political pressure. We even heard that SUNAT in Arequipa discussed, and this is something that was discussed yesterday, addressed not only the specific case but also the global situation in Arequipa. My question is very specific. Would you please tell us whether you have received any sort of question that would convey some political pressure as part of your activity, and that law clerk Villanueva may be considered as a parachuter that you launch to the room along the same lines of political pressure to resolve the issue one way or the other? Let me answer. I have not had any political pressure. Here, there was only a resolution based on the technical and legal issue. At any time, did we have any political pressure of any type? Are you aware of having received any call, any intervention by someone that may move the decision one way or the other? No, I have not received any phone calls, and I can say that throughout my tenure as president, the ministers were very respectful of the independence, of the operational independence of the tribunal. I never received any call regarding the resolution of a case.
Please go ahead. Yes, we can take a break, 15 minutes. And let us continue.
Thank you, Madam President. Ms. Olano, you said that Ms. Villanueva had a carga de confianza. She reported directly to you, and you had the authority to remove her without cause. But with regard to law clerks did not have a cargo de confianza, so they only could be laid off if there was cause, and they do not report directly to you, but to the president of the chamber. Is that correct?
No, it's not correct, and I can explain why. Most of the professionals that are on the tax tribunal are under the CAS regime. Up until last year, it was not until last year that there was a change in the CAS regime, which now means that they are permanent. But before, the CAS hiring regime would last 6 months or 1 year. So you could simply not renew the contract without expression of cause. So it's not true that it was only for cause or anything of the sort. It was the same situation. And as regarding the CAS personnel, the one who sends the documentation to hire and to determine whether or not there's a renewal is me. Obviously, with the opinion of the chamber. Now, I don't know all of the law clerks. I only know them by reference, so I ask the chambers for their opinions to determine whether or not to renew the contract.
Clerks did not have a cargo de confianza, correct?
It was not a position of trust. It was different because the position of Ursula Villanueva is a directing or managerial position.
Before that, Ursula had a cargo de confianza, right? You still maintain that?
Yes, she was never manager.
That was a cargo de confianza, right? You had the authority to remove her without cause. That's what you testified. Is that still your testimony, right?
Yes, what I say is that she was designated like any other designation. It's a position of trust.
Ms. Olano, you could have assigned, instead of Ms. Villanueva, another law clerk to assist Chamber Number 1, couldn't you? You provided us with emails in which you showed that when other chambers had a staff shortage, you appointed law clerks from other chambers. And you could have done that with Chamber Number 1 as well, couldn't you?
Now, let's see. As I explained, in principle, the scenario was one of a shortage of personnel, and my witness statements include all the memoranda. Second, Ms. Zúñiga was the one who sought the support of Ursula Villanueva. So when they asked me for her support, I don't have the emails, it's true, but on several occasions I've been asked to provide Ursula Villanueva to provide support because of her experience. So it was not possible in every situation. In that case, Vocal Zúñiga asked for Villanueva's support because they wanted to make sure the case would be well reviewed, or they wanted her to take a look at it.
You could have told her that she should borrow the law clerk of Chamber Number 10. They were hearing a similar case. They were hearing another royalty case. They already worked on it. You could have told her that the clerk of Chamber Number 10 could assist her instead of Ms. Villanueva, couldn't you?
No, because I was not involved in the chambers. I would not go and remove a law clerk from one chamber to another. That would have to be coordinated with the vocales. When At the complaint office, which was created in 2013, there was a system of turns, which was discussed with the presidents of the chambers, that every so often a law clerk would go to that chamber. But it's not that I can take away a law clerk and from one chamber and put them in another one. There has to be coordination.
Well, you testified in paragraph 9 of your second witness statement that it was a well-established practice that when staff is needed, the chamber requests the assistance, and that you assigned them law clerks from other chambers, and you provided us 2 emails in which you appointed law clerks from other chambers. You could have done the same thing in this case, couldn't you?
The examples that I showed you, which had to do with resource management, yes, in effect, I showed you the issue of the complaints office where there were turns. And in the other one was the law clerk in the technical office. Obviously, I had to talk to the director of the technical office for her to be able to lend her law clerk.
Chamber number 10, whether they could lend their law clerk for chamber number 1? You didn't, right?
I did not do so because I had no reason to do so. I don't go into the chambers and ask whether a law clerk can be placed on loan. I don't even know quite what they're doing.
Kept on repeating that you assigned Ms. Villanueva several times to chamber number 1 or to other chambers. Again, you have not found a single resolution that bears at the end the initials of Ursula Villanueva in order to prove that point.
Well, I already answered, I think.
Let's come back to the point where we left it. So we said chamber number 10 had scheduled at the beginning of March a hearing for the beginning of April. On 23rd of March, you had that email exchange with Ms. Villanueva, and I followed up with the question that in that time period, in March, you did not inform chambers number 10 that Ms. Villanueva was not working on the case. And let me show you a part of the transcript from the SMM hearing where we talked about your functions of coordinating. That is tab 3 CE 1139. And we don't have the right page on, sorry. I have it here as 1769 226, that's in the English version. And in the Spanish, 1841 6 to 11. And it's line 226 on the English, and in the Spanish line 6011. And you said yes. What I said was that yes, I do coordinate among the chambers when they're looking at similar cases, precisely so that they can either reach agreement or see whether it's a matter that's going to have to go to the plenary chamber. You see that?
Yes.
Money?
Yes.
In the time period, again, until in the time period of March 2013, you did not contact chamber number 10 to tell them that Ms. Villanueva is working on the draft resolution for chamber number 1, did you?
Yes, but I already explained that I don't have an obligation to inform anyone about that matter. I have no reason to know. I am a nexus. I coordinate when there is a case, but it's not that I need to be looking so closely and saying, look, you coordinate with this. That I don't do.
Anyone else contacted chamber number 10 to tell them that Ursula Villanueva is working on a draft, are you?
I don't know who has communicated or if there's been any communication.
So in April, at the beginning of April, Chamber number 10 holds the oral hearing. And we now go to May 21st, okay? On May 21st, Chamber number 1 passes the resolution that Ms. Villanueva drafted, right?
A ver,
Let's see. As I have explained to you on several occasions, I can't decide that they adopted what was drafted by Ursula Villanueva because Ursula Villanueva was providing support. The final draft, I don't know who did it because it had to be looked at by Mr. Zuniga, or Ms. Zuniga, so I can't say that. I can't affirm that.
But you do recall, I mean, we can show it to you. It's in tab CE80. It's Exhibit C83, tab 20. But you do recall that on 21st of May, 2013, Chamber number 1 passed the resolution in the 2008 case, right?
Yes, you have the date of the session. In effect, what I can say is that on 21 May, as per the date of the resolution, the case was taken up in Chamber 1.
And that means that at that date, Chamber number 1 approved the resolution. Is that correct? They had a session in which they voted to approve that resolution, correct?
sí,
Yes, that's right.
And at that point in time, before they approved the resolution, Chamber number 1 did not have a copy of the draft resolution, correct? I restate my question. So before Chamber number 1 approved this resolution, Chamber number 10 had not received a draft of that resolution, correct?
I cannot say what I don't have personal knowledge of. The only thing is that there are some emails, and what I can say is what is said there.
Well, we worked through it in the last hearing. Let me show you an email that Mr. Moriano wrote on the 28th at 10:05 in the morning. That's in tab 6, CE 650. That's an email from that day, May 22nd. He wrote it at 10:05 p.m. Can you, just to recall again, Mr. Moriano was the president of Chamber number 10, right?
Yes, he was.
So he wrote at 10 in the morning. Where do we have that? There's a question regarding this. That's the wrong email, I think. That's from the next day. It's the 21st of May, the email, CE 650. Here we have it. That's the second one from here. He writes, Zoraida, a question regarding the Cerro Verde file. We were informed that Ursula Villanueva made a draft that was returned to Chamber number 1. Dr. Cayo tells me that he will coordinate with Lisette since we have the same subject matter. You see that?
Yes, I see it.
So it's at that time on Tuesday, March 21st, that Mr. Moriano finds out. He says, we were informed that Ms. Ursula Villanueva had made the draft, correct? May 21st.
bueno,
Well, what you have there was that at that time he wrote that email And I answered saying I spoke with Lisette, and she told me she already coordinated. That's what was my answer to him.
Moriano at that point in time informs you that he just heard that Ms. Ursula Villanueva made a draft, and that Mr. Cayo will coordinate with Lisette, will in future tense, right?
Of course, he speaks in the future, and the vocal from the chamber number 1 speaks in the past.
Well, at 10:47 a.m., so apparently it would be reasonable to infer that Mr. Cayo had what he called the coordination between 10:05 and 10:47, right?
You are speculating because here there's simply an email that indicates that where Vocal Moriano says that he said he recently found out and he's going to coordinate. And so I asked Vocal Zúñiga, who said that she already coordinated with the Vocal Ponente, because normally one coordinates with the Vocal Ponente. Now, you're speculating that in the interim he's coordinated? Well, that I don't know.
Not present at that coordination, right?
No.
Ms. Moriano sent you another email. That's step 13, CE 992. That's an email from the 22nd of May. He writes that at 11 in the morning. And he writes to use Zoraida, that coordination was done by Luis Cayo, the vocal ponente, with Lisette, because I told him to call her, since we found out extra officially that Ursula Villanueva had already delivered the project, and the chamber number 1 was going to take up the Cerro Verde case file yesterday. Chamber number 1 did not previously inform us that it was going to meet yesterday morning, let alone hand us its project to coordinate, which only reached us today. That's May 22nd, the day after the resolution was approved, in which I find out that the chamber number 1 case file was taken up yesterday morning. With all due respect, I don't think that was the right thing to do. You see that?
Yes, I see it. That's why I immediately forwarded the email to the president of Chamber 1, Ms. Zúñiga, to see what had happened, because I didn't understand. And then she answers saying that, yes, she had spoken with Vocal Cayo and had said that they were in agreement. And they had left it that she was going to send the draft after the session.
She spoke with him after Mr. Moriano told him to call Lisette, because they just had found out the day before that Ursula Villanueva had already delivered a project, right? That's what he says here.
I'm sorry. I'm sorry to interrupt. The email that she's referring to below is not translated into the English translation. Could you read it into the record so it could be translated for everyone else?
You can do that on redirect if you want. Mr. Moriano here says, chamber number 10 found out yesterday that Ursula Villanueva had a draft. He told Mr. Cayo to call. They had that, what you call the coordination, and the draft reached them only this morning. So he received the draft of the resolution only after it had been passed, right?
Let's see. That is what Mr. Moriano says, and Ms. Zúñiga indicates something different. That she had already coordinated things with the vocal ponente, and that she was told that all of the vocales were in agreement and that the draft was going to be sent after the session. They had agreed on that.
No. The email that you mentioned from Ms. Zúñiga, let's take a look at it, because Mr. Moriano replies to that email. He replies to Ms. email, to Ms. Zúñiga's email. Ms. Zúñiga said, Zoraida, según conversé con Luis Cayo, antes...
According to my conversation with Luis Cayo before the session, they were in agreement with confirming things, and we thought that the terms of the decision were quite clear, and that they would not bring about any discussion. So that we said that after the session, we're going to send a copy of the draft to coordinate any kind of adjustment, which I said yesterday immediately after the session. I'm sorry that this brought about some discomfort, but that was not intentional.
That she's no. So she confirms that the draft of the resolution was only sent after the session. Correct?
Yes.
Mr. Moriano then replies to that email and clarifies. He says, wait a second, that coordination was done because I told Luis Cayo to call her, Ms. Zuniga, who is the president of Chamber Number 1, since we found out extra-officially that Ursula Villanueva had already delivered the project and that Chamber Number 1 was to take up the file yesterday. Chamber 1 did not previously inform us. So he clarifies here that the call took only place the day before and that he actually did not receive the file after on May 21st after the session, but he only received it this morning, right? So he corrects Ms. Zuniga. Isn't that what he says?
A ver,
I'm not sure whether he's correcting or not. There's two assertions here. The truth is that Mr. Moriano is nowhere here saying that he is not in agreement with the draft. He says that he's sorry and because of an issue of formatting, but what Ms. Zuniga did was coordinate things with the vocal ponente, that's what she says, and she also says that Mr. Cayo, who was the drafting vocal, he said that the other vocales were in agreement. Now, how the final draft of the project is, that's something different. They said after the session that was the final thing.
That Mr. Moriano and Chamber Number 10, they held their oral hearing. They had a draft prepared of the resolution. They suddenly find out that actually Ursula Villanueva had drafted a decision in the 2009 case, and that resolution was actually voted on, and they only received the draft after that resolution. That's what happened, right?
No. You're speculating that there was a prior resolution. I cannot assert that because I don't know that. He never said here that he had a draft. He was not the ponente. Cayo was the ponente.
Ms. Solano, you testified today that any diligent chamber that goes into a hearing has a draft prepared or has at the minimum carefully thought about the issue. Since that hearing, a month and a half had passed. You're telling me that they didn't have a draft? Do you know that?
I'm not saying that they had a draft or that they didn't have a draft. I cannot assert something that I have no personal knowledge of. What I've said is the ideal would be that, but if there is no draft, then discussions are had amongst the vocales because they're going to go there and they should have knowledge of the matter before they go to an oral hearing. They're going to be listening to the parties and they have to ask questions, right? So you can't go there without knowing what's it about. So I cannot know whether they had it or not. You're speculating that there was a draft and there was a draft that said something that was different. That's speculation. That's your speculation. That's where you are imagining it.
Ms. Solano, you just testified that you don't know whether they had a draft or not. You don't know that they did not have a draft, do you?
no
I do not know.
sé si no.
I do not know whether they had or they didn't have a draft. I have spoken hypothetically.
Miss Solano, Chamber Number 10 had the file since 2010. You testified that Mr. Cayo, who's the reporting judge, got the file in 2011. They had the oral hearing at the beginning of April, and you testified that in Spanish. Idealmente, cuando hay un
Ideally, when there is an oral report, there must be at least a draft.
Another month and a half have passed. Chamber number 1 clearly had a draft ready, and that is why Mr. Moreano was so upset with. Chamber number 10 had at least a draft ready, and that's why Mr. Moreano was so upset when he wrote you the email. Isn't that the case?
That is not true. At least I cannot assert what you are imagining. Again, what I've said is that generally when there is an oral report, and I cannot say whether there was or there was not a draft, well, the ideal thing would be for a draft, a pre-draft to exist, and the vocal that has the draft lets the other two vocales know what's it about, so that when they hear the parties, they know what the case is about. If there is a pre-draft or a draft, well, if there was one there or not, I cannot assert that. That's your imagination. If Moreano, who was not the ponente, I don't know why he would be upset. It wasn't his draft. There was another vocal that was the ponente, and he said that they had spoken, and you're saying that the presiding vocal that did not have the file had a different draft, and he was bothered by that. That's what you're saying. But that's your imagination. I cannot know that, and I cannot assert that. It would be strange to me that the president of the chamber be so upset when he has a draft. But the drafting vocal is the one that handles the case, and he has to provide support to the other two vocales.
Solano.
Perdón, el doctor Moreano.
Mr. Moreano also voted. He also signed, and he wanted to know what was in there. Yes, he voted, yes. I understand that, but the one that explains the draft is the ponente. I look at what counsel has said. He assumes that the vocal ponente had a draft and that he was upset because there was another draft in there. I am not able to know those things. The presiding vocal, who was not the ponente, had another draft at hand, but generally the vocal ponente generally is the one that coordinates things. So there were two chambers with a similar case of two different periods, and they were deciding at the same time. Apparently, the chamber called the oral hearing, and there was a law clerk there, and then the resolution was made by Chamber 1. What we are not taking into account is what Mr. Cayo says. The draft includes the decision. What I've said here and in other hearings is that the vocales in the chamber surely knew about the matter, because if there was an oral report that took place 2 months before, then they knew what this was about. And according to Ms. Zúñiga, Cayo had told her that they agreed. So the language includes the decision made. Perhaps he was upset formally. Why didn't you give me the draft before? Because I wanted to correct something here or there. Perhaps he was just formally upset, but not substantially upset. What it says here is that they were coordinating, but Moreno hadn't seen the draft, apparently, and that the draft was sent to him when the decision was already made. But Cayo was the vocal ponente, and he said that the vocales were in agreement, and that's included in that email. And he tells Zúñiga that there is agreement. At no time did Moreano say, I disagree. We had another draft. Nowhere in the email it says that. He expresses that he is upset as presiding vocal. You should have coordinated this with me as well. There was no coordination, but nothing else. I cannot assert that there was something else different from that.
So, Ms. Olano, the chamber number 10 now is suddenly put in front of the following dilemma. It either has to accept the criteria of the decision that chamber number 1 had just rendered without letting them know, or it can go to the plenary chamber if it disagreed with that criteria. Isn't that the case?
Well, if Chamber 1 has already held sessions, then Chamber 10 had the option, if it disagreed, if the three vocales disagreed, and also the ponente was in disagreement, to go to the plenary session to ask for a change in criteria, or at least to express their disagreement. If I am so mortified because I had another position, I can show my discrepancy. That resolution was rendered without any dissenting vote. Mr. Moreano was a vocal that usually submitted dissenting votes in resolutions in the plenary chamber. So if he wanted to show his disagreement, he could have rendered a dissenting vote.
But the royalty cases should all be decided according to the same criteria, wasn't it?
Let's see. It's not only my position, it's what the tax code says. There is uniformity of criteria. So if there is a criteria that the tribunal has, the next one has to be decided in a similar manner. If there is disagreement, this has to go to the plenary chamber and the criteria has to be changed. And the vocales will decide whether it will be changed or not.
The position was not that the plenary chamber should decide what the right criteria was. Your position was that once a first decision in a royalty case came out, which was the 2008 royalty case decision, that all the other royalty cases should follow that criteria of the chamber number 1 decision, wasn't it?
Sir, I insist. It's not that that's my position. That is what the code provides. If there's a certain criteria in the tribunal, the next case has to follow that criteria. Otherwise, there will be conflicting decisions, and this has to be taken up to the plenary chamber. Now, if there's a disagreement, you can take this to the plenary chamber. There are no impediments. You were the one that directs the plenary, right? Yes, I am one more member with vote. And you direct the plenary chamber? Yes, I direct the plenary chamber. That's in the code.
Olano, on the 24th of May, which is 2 days after you received the email from Mr. Moreano, you arranged for a meeting with Vocal Cayo from chamber number 10, and with Ms. Zuniga from chamber number 1, right?
Sí.
Yes.
And you testified that the purpose of the meeting was for you to coordinate between the two chambers, right?
Yes.
What was there to coordinate, given that chamber number 1 already had voted on its resolution? That coordination came too late, wasn't it?
No. We had to see what had happened. As you've explained on the emails, what Mr. Moreano said, and there is another email that says something different. Ms. Zuniga says something different. So I wanted to know what had happened. That is why Cayo also informed that the vocales were in agreement. That is why I said to you that he was upset only in form. It's not that there was a disagreement. I wanted to know what had happened. There were two presiding vocales. One said A and the other one said B. So I wanted to know what had happened in connection with the coordination.
After you held that meeting, which was on a Friday, the following Monday, the 27th of May, the tax tribunal notified the 2008 decision to SUNAT. And 3 days later, on the 30th of May, Chamber number 10 votes on its 2006-2007 royalty case resolution. Do you recall that?
Let's see. The exact dates, I'm not sure. Once the decision is rendered, it goes to the technical office. If there are no objections, it follows the procedure. And back then, now things are different, the notices are given electronically. Now, because of an agreement with SUNAT, the resolutions were sent out so that the taxpayer could be notified.
8 resolution. And I will now show you a demonstrative that compares the 2008 resolution of Chamber number 1 with the 2006-07 resolution that was rendered by Chamber number 10
I'm sorry,
a few days after your meeting.
This isn't cited in her witness statement.
I'm sorry, the whole witness statement is about the 2006, 7, and 2008 cases.
No, it's not. She did not decide either of those cases, and she wasn't involved in the drafting of the resolutions.
The whole witness statement is about the process of how those resolutions came about.
And we have one of the vocales from Chamber 10 who was involved.
Yeah, you can ask him. You can ask him
testify about
questions.
this.
You can ask him questions. Did Ms. Solano?
It's outside the scope of her testimony.
Yes.
Please go ahead.
Does Ms. Solano have a copy? Yeah. Oh, okay. Ms. Solano, you see here the text in black without underlining is identical in the 2008 resolution and the 2006-07 resolution. You see that?
Sí.
Yes.
You can feel free to take a look at the actual resolution. You would agree with me that the vast majority of the text between the 2006-07 and the 2008 resolution is identical.
Let's see. I think in the last hearing I also said that these were similar cases and the arguments were similar, and therefore these two things, I'm sure, looked like each other. And the appeals provided by the taxpayer were different and the arguments were different, but the arguments by the tax authorities were similar. Normally what happens is that when you have similar arguments by people, they're similar.
Ms. Solano, this cannot possibly be the resolution that Chamber number 10 had drafted without coordinating previously with Chamber number 1. This is the resolution that Chamber number 1 received on May 22nd from Chamber number 1 with some amendments.
That is your statement, not mine. I'm not going to qualify these decisions. Ultimately, is the discussion and the agreement. The drafting really shows and evidences the agreement. it says here, well, they do this in conformity with the regulations. And the other one, they're alleging the same thing. So these are similar texts, and I'm sure there have to be similarities, but this does not impact the substance of the matter.
Ms. Solana, the discussion about adopting this text took place at your Friday meeting on 24th May 2013 that led Chamber Number 10 to adopt the draft that Ursula had prepared for Chamber Number 1. Isn't that the case?
No, I don't know.
The questions.
Before we continue with questions from the respondent and redirect, I would like to better understand one aspect that you have mentioned earlier. You mentioned some transparency requests as to which you produced emails, or according to claimant withhold emails. Can you explain to us who made this transparency requests and when?
Yes. There are some transparency procedures that have to do with access to information by the public. Any individual can submit a request. Cerro Verde provided requests, and some others that were not Cerro Verde people, but they asked for a number of emails that covered long periods. If memory serves, I think first period was from 2020 to 2015, then from 2016 to 2020. If memory serves, they asked for emails from the president to the vocales, to the technical office, to different addressees. We're talking about a large number of emails. I wasn't the only one asked to provide emails. Others were as well. And also other documents that were asked according to a request for transparency. These were old emails. It was a large number of documents. And we asked the IT office of the ministry to provide support so that they could look for those old emails that sometimes you don't see. They provided to me an assistant, and with the assistant, we were able to determine, the assistant got all the backup of those emails and extracted those emails, and I told him, look for the word health and take everything out that has to do with health. For example, physician certificates and things that were private. Nobody had to find out about that. And that was what was left, right? A large number of emails with a lot of information was what was left. And this was, I think, sent out via a link that is handled by a different office. We sent this to the office, and the office sends this to the interested party.
And do you remember when these requests were made?
In a number of years.
20 or just
2018,
2018, 2020, we have had requests in a number of years. I don't remember the dates exactly.
And you say you had requests in a number of years, but not only related to Cerro Verde, but also related to other taxation proceedings?
Well, we got a number of requests under the transparency regulations. In that specific case, we were asked to provide emails. Other documents were also requested from us under the transparency rules. I remember that Cerro Verde, there were specific requests in connection with Cerro Verde, and Also, there were other requests made by people who I didn't know that they were related to Cerro Verde, but they also asked for emails.
So, in Peru, if a taxpayer has questions as to the irregularity or regularity of the proceedings within the tax tribunal, would he or she be able to file such a request under the transparency rules right away? Or when is such a request founded? What does the applicant needs to establish?
Bueno,
There is also a procedure to provide complaints before the tax tribunal. There are complaints against the tax administrations and against the tax tribunals. Those complaints are presented and they are dealt with by the Ombudsman's Office for the taxpayer.
And is there some sort of a time bar for complaints or for such a request for transparency, or can the taxpayer come whenever he or she considers it appropriate?
In connection with transparency, things are different. This has to do with access to information. Anybody can ask for any piece of information. We were asked to provide information about the IT system and how it works. We have been asked to provide the procedures manual, all of the memorandums that we have issued. We have asked for all documentary and email information, and we are obligated to provide that information. There is a special office at the ministry that deals with transparency requests. The requests are sent to us, and then we act accordingly. In connection with the complaints against the tax tribunal, well, I don't remember if there is some kind of time bar, but no complaints can be placed against the resolution itself, because you can then go to the courts. Because if you don't agree with the resolution at the administrative level, you then go to the courts. If there is a procedural matter that wants to be pointed out, then that could be part of the complaint. I don't know. Perhaps the responsibility of officials could be something that could be the subject matter of a request. These are different processes that could have taken place.
And my final question is, since when do these transparency rules, this access to information law exist in Peru?
Si usted no sabe, no sabe, no se preocupe. 2003 or 4, I don't remember the date.
So they
Así que existía en el momento en que se emitieron las resoluciones.
Switch channels, please.
Sorry about that.
So in any event, these transparency rules already existed at the time the Chamber 1 and Chamber 10 resolutions were passed?
Yes, I think so.
So if one had doubt on the regularity of the proceedings, one could have submitted a request for access to information already at that time?
Yes. What couldn't have happened back then is that we couldn't have provided the draft resolution, because that was still being looked at. Then, at the end of the process, then yes, you can provide that information.
Thank you.
If I could just have 1 minute to confer with my colleagues, then I'll let you know. Madam President, just to clarify, you had asked about a request for transparency, and there is on the record an exhibit CE 1092 dated February 10th, 2021, which is titled SMCV Request for Access to Information. Just for the record.
Exactly, it's dated 2021.
Mm-hmm. And we have no redirect questions.
Does the claimant have follow-up questions to the tribunal's questions?
No follow-up questions, thank you.
Ms. Olano, the tribunal has also no further questions, so you are released with thanks as a witness. Thank you.
Muchas gracias.
Thank you very much.
Would the parties agree that this is a good time for a lunch break, or do we want to continue with the next witness?
I think it's probably a good time for lunch break.
Okay, then we will have a lunch break for 40 minutes, which means that we will see us again at 1:15.